The nation is once again captivated by a legal drama unfolding in the highest court of the land. Former President Donald Trump, a man accustomed to dictating terms, not following them, finds himself in the unfamiliar position of being a defendant. At the heart of this case is a subpoena, a legal order demanding his testimony before a grand jury. This subpoena, issued by Special Counsel Jack Smith, is no ordinary summons. It delves into the tumultuous events surrounding the 2020 election and Trump's alleged attempts to overturn the will of the American people. Trump, in a move characteristic of his combative legal strategy, is petitioning the Supreme Court to intervene. He seeks to halt the subpoena, claiming it infringes upon his rights and sets a dangerous precedent for future presidents. This legal maneuver, if successful, could have far-reaching implications for the ongoing investigation into the January 6th Capitol attack. The nation watches, holding its breath, as the judiciary prepares to weigh in on a matter of paramount importance, the balance of power and the pursuit of justice. The courtroom, a stage where legal battles are fought and history is written, awaits the Supreme Court's decision. Will they side with the former president, potentially shielding him from further scrutiny? Or will they uphold the lower court's ruling, allowing the subpoena to stand and the investigation to proceed unhindered? The answer, eagerly anticipated by both sides of the political aisle, promises to shape the nation's understanding of presidential accountability and the rule of law. Trump's journey to the Supreme Court has been fraught with legal setbacks. Lower courts tasked with initially reviewing his claims have consistently rejected his arguments. These courts, interpreting the law and precedent, have found no merit in Trump's attempts to quash the subpoena. They have ruled that no one, not even a former president, is above the law or immune from a grand jury investigation. These rulings, while a blow to Trump's legal strategy, underscore a fundamental principle of the American justice system: equality before the law. Regardless of one's wealth, status, or former position of power, all citizens are subject to the same legal processes. This principle, enshrined in the Constitution, is the bedrock of a fair and impartial judiciary. Trump's legal team, however, remains undeterred. They argue that the lower courts have erred in their judgment, failing to fully grasp the implications of compelling a former president to testify. They contend that such an action would set a dangerous precedent, potentially opening the door for politically motivated investigations against future presidents. Their appeal to the Supreme Court is a last-ditch effort to overturn these rulings and shield Trump from further scrutiny. The crux of Trump's legal argument hinges on the concept of executive privilege. This legal doctrine, enshrined in the Constitution, protects certain communications between the president and their advisors from disclosure. It is intended to ensure the free flow of information and candid advice within the executive branch, ultimately enabling the president to effectively carry out their duties. Trump's legal team argues that the subpoena issued by Special Counsel Smith infringes upon this privilege. They contend that the requested testimony, pertaining to Trump's actions and conversations during his presidency, falls under the umbrella of executive privilege and should therefore be protected from disclosure. This argument, if successful, could significantly limit the scope of the investigation and potentially shield Trump from accountability. However, legal experts are divided on the strength of Trump's claim. Some argue that executive privilege is not absolute and can be overruled in certain circumstances, particularly when there is evidence of wrongdoing. They point to past cases, such as the Watergate scandal, where courts have compelled presidents to disclose information despite claims of executive privilege. The Supreme Court, in their upcoming decision, will need to weigh these competing arguments and determine whether executive privilege, in this instance, trumps the pursuit of justice. The nation now awaits the Supreme Court's decision, a ruling that could have profound consequences for both Donald Trump and the future of American democracy. The court's 9 justices, appointed for life and wielding immense power, hold the fate of the subpoena in their hands. Their decision, expected in the coming weeks, will determine whether Trump can successfully evade accountability for his actions, or whether he will be forced to answer for his role in the events that shook the nation. The implications of the court's decision extend far beyond this particular case. A ruling in favor of Trump could embolden future presidents to operate with a sense of impunity, knowing that their actions, even if potentially criminal, may be shielded from scrutiny. Conversely, a decision upholding the subpoena would send a clear message that no one, not even the most powerful person in the country, is above the law. The stakes are incredibly high, and the nation watches with bated breath as the Supreme Court prepares to deliver its verdict. Will justice be served, or will it be delayed, perhaps even denied? The answer, when it comes, will reverberate through the halls of power and across the nation, shaping our understanding of justice, accountability, and the delicate balance of power in a democracy.